Welcome to Legislation Explanation. Today's date is Sunday, January 7th, 2024. On January 3rd, the U.S. Department of Justice filed a lawsuit against Texas in an effort to overturn the recently passed immigration law, referred to as Senate Bill 4. So what does Senate Bill 4 do? Why is the federal government challenging it? And what gives them the legal right to do so? Before anything else, we need to go back a bit to understand the state law in question. In November of 2023, Texas's legislature, its House of Representatives and Senate, passed Senate Bill 4. On December 18th, Texas Governor Greg Abbott, the head of the state's executive branch, signed the law, agreeing to enforce it. When the heads of the two branches are in agreement, a bill becomes a law and will go into effect. This particular law is set to go into effect in March, but what would it actually do? The text of the law is only 11 pages, so we can read through the major points together. It will also be linked in the description along with all other sources, so you can feel free to read it on your own. The law opens by stating that it relates to prohibitions on the illegal entry into or illegal presence in this state by a person who is an alien, the enforcement of those prohibitions, and authorizing or requiring under certain circumstances the removal of persons who violate those prohibitions. Essentially, it relates to illegal immigrants in Texas and the standards by which they can be removed from the state. Section 1 starts by listing certain places that officers may not arrest someone in enforcement of the law. These include primary and secondary schools, places of worship, and various healthcare facilities. As these are exceptions, an arrest could take place anywhere not listed. The law gives state judges the ability to issue a written order that requires the person to return to the foreign nation from which the person entered or attempted to enter the state, and requires the order be given if the individual is convicted. Article 5B.003 says that courts may not delay prosecution even if the federal government has not yet reviewed the immigration status of the individual on trial. Section 2 begins by defining certain terms and clarifying the means by which an immigrant can or cannot defend themselves from prosecution. If the individual repeatedly attempts to enter Texas and/or refuses to return to the foreign nation from which they entered, that person would be charged with a felony, which comes with higher penalties. This can mean up to 20 years in prison, according to the governor's press release relating to the law. The law goes on further, but these sections are most relevant when we discuss the federal government's response. The Justice Department's press release claims that Senate Bill 4 is invalid because the Constitution assigns the federal government the authority to regulate immigration. One of the key points of the United States Constitution is that the federal government has supremacy over the states, meaning if the U.S. government has a certain power or makes a certain decision, individual states cannot take that power for themselves or make decisions that contradict the federal government. This supremacy clause is important because without it, states could do whatever they want, even violate the U.S. Constitution. At that point, we would essentially have 50 different countries instead of one unified country with 50 states. In regard to Senate Bill 4, the federal government argues that only they have the power to manage our international borders, including cases in which people cross those borders, both legally and illegally. They additionally argue that only the U.S. has the authority to order the removal of individuals from the country. Ultimately, this lawsuit will be tried in a federal court, and may even make it to the U.S. Supreme Court, which has reviewed disputes like this in the past. We will see what is decided then, so stay tuned for further updates. Before we go, here are this topic's reflection questions for you to consider and answer in the comments below. Question 1. What is an example of a negative law or action that could occur in a state if they did not follow the U.S. Supremacy Clause? Whether you support or oppose Senate Bill 4, think of another example that you imagine could be an issue. Question 2. Texas Governor Greg Abbott claims that the federal government is not doing enough to enforce U.S. immigration laws, which is why Senate Bill 4 is necessary. Do you believe that argument will convince the courts to allow the state law to take effect? Why or why not? If you found this video useful, please consider liking and subscribing, and share with others to spread the knowledge. Follow me on social media for updates, and I'll see you next Sunday.